All right, you should be seeing this as your first video in the American Tort System. I'm Gus Nelson, and I'll be teaching the course. Just to give you a quick little snapshot of my background so you can feel comfortable that I know what I'm talking about. I've been an attorney since 1988. I have practiced for many years in the area involving torts and tort law, particularly automobile accidents, both on the defense side and on the plaintiff side. So I've seen it from both sides, and still continue to work in the legal field. Although I'm not actively practicing law in Kentucky where I live right now, I am still working for a law firm that does tort law. So I continue to be involved in that and do quite a bit in terms of writing and engaging in sort of behind the scenes decision making, if you will, about some of the things that we will talk about in this course. So it's something I've been doing for years and years and years, and it's been a major part. And I've tried literally hundreds of cases involving car accidents and other issues in tort law. So, I mean, this is something that I've just lived pretty much my entire professional life. So just so that you can feel like, yeah, I'm not coming out of left field, or it's not just purely academic for me. We're going to start the course by talking about negligence versus strict liability, and some of you may find this to be an odd place to start. Why not start with some more fundamental principle? Well, I do think this is a fundamental principle in American tort, in the American tort system. For the most part, in the American system, negligence is the big way in which we decide whether people have tort liability or responsibility for their actions. As you may know, a tort is a civil wrong not arising out of contract. That's the general definition of a tort. And the big issue oftentimes in tort cases is, how do we figure out whether one person has engaged in a civil wrong not arising out of contract for which they owe some duty and responsibility to compensate another person? And that's what we're talking about here. We're talking about a system in which we intend for one side to have to compensate the other side for something that has occurred in which one person has been injured and the other person has been the cause of the injury. Negligence theory creates a standard which we usually refer to as reasonable care. The idea is that if I engage in reasonable conduct, then I'm not responsible even if I cause someone else an injury. Now, we'll talk about this in a minute, but the query you might have is, well, if you cause someone else an injury, how could you have done it in such a way that you engaged in reasonable care? It almost seems impossible. And that would be correct probably most of the time, right? It's very unusual for somebody to harm somebody else and do it in such a manner in which they have engaged in conduct that was completely reasonable. But we'll talk about that, because that is in fact what happens in strict liability cases. And so that's why you can see we need to talk about this. Negligence generally indicates that an actor has caused a harm and where they have violated a standard of some kind. And typically it's what we call reasonable care. That is the idea that you have violated essentially what we might call a community standard. Typically this means that we look to how people behave in a given community under the same circumstances. For instance, and driving is a typical one, right? How do people behave when they drive? Well, for the most part, in my experience, driving is seen as something that reasonable standards that apply are pretty much similar around the country. That is, if you're speeding, then oftentimes you would be deemed at fault for an accident if the other person isn't speeding. If you run a red light, that's generally seen as inappropriate behavior, and it may not have been malicious or intentional, but nonetheless it's seen as unreasonable, and if it results in harm to somebody else, typically the person who ran the red light bears responsibility. And we see that as, hey, we just enforce that liability on them because they've acted unreasonably. Strict liability, on the other hand, imposes costs on an actor regardless of their care. That is, I may be taking the utmost care to do the activity and nonetheless still do something that injures somebody else. And if we have a strict liability standard in a particular instance, we nonetheless impose a compensatory obligation on the part of the actor. And so that's the thing we're weighing right now, is this difference between, well, do we want to have strict liability for everything, right? I mean, and there is a sense, if you think about it, and Geistfield, sorry about that, Geistfield, your author, he touches on this, but we could certainly look at this and say, listen, you know what? If you harm someone, you have to pay them. And that it's only reasonable that the person who does the harming bear the cost of their activity. And so that's not an unreasonable position to take, right? I don't know. Well, that's one of the things you'll be talking about in the very first comments that you do back and forth on the message board, is that you're going to be dealing with each other back and forth and asking and I'm going to ask you the question, which would you think makes the most sense, and ask you to support your response. Basically, we have to make a philosophical decision here. Which one do we think is the most beneficial to society? That's what it kind of boils down to. So let me ask you this question. Well, does requiring strict liability mean actors will necessarily engage in less risky behavior? It would seem that if you say, hey, you're always responsible for whatever damages you might cause someone, the implication would be, well, then people will really think carefully, because if they know they're going to have to pay for it, right, they might not do it as much. Well, not so fast, right? Because you think about it. What it might simply mean is people are much more callous about their behavior. They might just do a quick calculation every single time. We kind of assume a rational actor, which is a debatable proposition if you've observed human nature. But nonetheless, if we assume rational actors and we say, well, hey, you know what, if we impose strict liability on everybody, that is, you pay for any damage you cause, regardless of whether you've behaved reasonably or not, people then it just boils down to making a quick calculation. Is it worth my time and energy to engage in the behavior? And if it is, well, fine. Then I'm going to engage in the behavior and just pay. I'll just pay for it. I'll pay the tax, if you will, for the behavior. The tax being the cost that I have to bear in order to engage in the behavior. That then creates certain incentives, quite frankly, for people to make those kind of calculations before deciding about behavior, right? And maybe we don't want that kind of calculating regarding behavior. One of the other kind of issues here is that there's sort of a moral component here. Do we think that people who harm somebody else just ought to always pay for it because they created the harm? Do we want to say, look, you created harm, you got to pay for harm, regardless of whether you intended to create the harm or whether you accidentally did the harm? And intentional torts is something else we'll talk about. It's a little bit different, and it's outside of the scope of the discussion right now of strict liability versus negligence. So let's keep it there and just talk about the idea of, well, suppose you inadvertently harm somebody. You don't have any moral culpability, right? I mean, that's kind of how we look at it. But is that true? Again, if you inadvertently run a red light, are you morally culpable? And do we even care? Right? That's one of the things we have to ask ourselves. Do we even care about moral culpability? Or is this all just a matter of moving resources around back and forth between people in order to make sure that those who suffer an injury receive some kind of compensation? I mean, is that what the tort system's supposed to be about? And so as we think about these things, we have to consider those factors in determining how we measure negligence versus strict liability, and considering whether we think one or the other is a better alternative, or whether we think some mixture of the two is the better alternative. Fact of the matter is that if you are responsible for your actions as a result of a negligence analysis, the calculation isn't nearly quite as simple as it would be in strict liability instances, and Geisfield does a good job of explaining this and laying this out for you. Just briefly, I'll just point out that when you make your calculations, as it were, in a negligence circumstance, you can't quite be sure whether you are in fact living up to the reasonable care standard or not. You just don't ever know exactly. That uncertainty, and Geisfield, I don't recall talking about this specifically, but I think just as someone who's been around and seen this for years, that uncertainty about whether or not I'm going to be held responsible is a factor in many people's actions. They behave a little differently when they're not sure whether their actions are going to cause them to have to pay something, right? And so maybe what we get, ironically, at first we might think, well, strict liability, yeah, you force the person to pay whenever they cause harm. If you cause harm, you pay. If you cause harm, you pay. That'll cause people to really make their clear calculations. They won't engage in as much risky behavior because they'll have to pay for it, and they know up front. But if you know up front, you know exactly that you're going to have to pay for it, then you can fold that in, right, to all your calculations about how you behave in the world and how you allocate your resources, and you just fold it in. And if you kill a couple people along the way, I'll just pay for it. I don't care, right? I mean, you could act that way and make your calculations that way. So, one of the things that you have to do when you're thinking about whether you want to do strict liability versus negligence is you have to think about the idea of, well, in negligence circumstances, there's uncertainty for me in what I'm going to be held responsible for doing or not doing. And as a result, because I'm uncertain, there's a additional calculation that I sort of have to make in my mind, and I have to create a buffer, if you will, right? In making my calculation, I can't just simply say, well, it's going to cost me $10 to engage in the activity, and I might cause $5 worth of harm, so I need to set aside $15 in effect to engage in that activity. Well, if in a strict liability sense, there you go. I've done it. I know what it's costing me, 15 bucks. Well, in a negligence circumstance where I'm held to a standard of reasonable care and I can't be 100% certain whether I will be held responsible or not, I can't know if it's going to cost me 10, or is it going to cost me 15, or maybe it costs me $17.50. And maybe $17.50 is too much for me. I don't want to bear that much expense. And so maybe I think, I'm just not going to engage in that behavior at all because I don't want to take the chance that I might have to pay $17.50 to do it. Hopefully that makes some sense to you. In other words, that the uncertainty does add a little bit of additional action on the part of me in thinking about what kind of behaviors I'm going to engage in. Geisfield talks about reciprocal behavior versus non-reciprocal behavior as a basis for negligence versus strict liability, and I think he's got a very good point here. We look at reciprocal things and we say, well, look, if everybody engages in the behavior generally, then we're going to impose a negligence standard, whereas if it's a behavior that most people don't engage in, we're going to impose strict liability. Blasting is the classic example. If you're going to be using dynamite, you are strictly liable for the consequences of your use of dynamite because very few people use dynamite. Why would we do this? Well, in the standard situation of driving a car, which is the easy one, everybody drives a car. Not everybody, but you know what I mean. Most people drive cars. It's a behavior with which most people are familiar. Most people understand how to drive a car. Most people know the risks associated with driving a car. And there is a reciprocity in the sense that we're both on the road at the same time. All right, both drivers who crash they're on the road at the same time, and so they sort of have a reciprocal obligation to watch out for each other. Whereas the person using dynamite and blasting, 200 yards down the road from my house, I don't I'm not engaging in blasting, nor do I have the capability for necessarily figuring out how to protect myself from his blasting. I don't know what to do about that. I may not even know it's taking place. There's no no reciprocity going on, and so perhaps that's a time, as Geisfeld suggests, in which we make the blaster, if you will, strictly liable. We say, look, the other party doesn't know what you're doing, can't respond to what you're doing, isn't going to respond to what you're doing, and you should therefore bear the full brunt, even if, and here's the key, even if you are acting reasonably. We don't care. We still hold you responsible. Now, see, and you can start thinking about this in this way. Well, so when you engage in that kind of activity, blasting, for example, then you must make the calculation, the simple calculation. I'm going to engage in the activity. It's going to cost me X to engage in the activity. There's a certain amount of risk, Y, in engaging in the activity, a certain amount of risk of causing injury, and that will tell me the total cost of engaging in the activity. And so I look at that and I go, okay, the risk of injury is Y, the cost of injury is Z, and the cost of engaging in the activity in the first place is X. I put that all together, I know what my costs are, and I just have to be prepared to pay that in the event of injury, whether I do everything possible to avoid it or not. There's the basic methodology for looking at strict liability. Uh, Engaging, when you're talking about tort liability, okay, the fact is that neither side in a tort situation, negligence situation, neither side in a negligence situation is going to make the calculation the same way. There's always going to be that effort to sort of engage in the behavior, think about how to best engage in the behavior, and then impose responsibility when one person doesn't live up to whatever the reasonableness or community standard is. And so those are the two sort of fundamental ways in which we look at liability in the United States. Now we have a third aspect of this with intentional torts, which we will get to. But that's a different kind of animal altogether, and we're going to shove that aside for now and just think of strict liability versus negligence as our two basic means of holding people responsible for their tortious behavior, which is a civil wrong not arising out of contract. All right, so read Geisfeld, correspond with your fellow students about this issue, and I will talk to you again next week, and I'll interact with you some as you go along with your interactions with your fellow students. Thanks.